Imagine for a second that you're making a completely life-altering decision.
Right.
Maybe it's about your health or, your finances or even your freedom. And to make this decision, you are relying on the unvarnished advice of an entirely independent expert.
Like someone you implicitly trust.
Exactly. You trust them. The whole system trusts them. But what if you found out after the fact that before this expert even walked into the room to evaluate you, someone had handed them a secret, written list of things they were legally forbidden to tell you?
Man, it completely shatters the foundation of trust. Because at that point, I mean, you aren't getting an expert opinion at all.
Right.
You're getting a highly choreographed performance that's just, masquerading as objective truth.
Which brings us to today's mission. We're going to unpack a really remarkable legal motion that drags this exact scenario right into the light of day. Welcome to the deep dive, by the way.
Glad to be here for this one. It's a wild case.
It really is. We're looking at a filing from the Supreme Court of New York, Queens County. The case is Enid Tovar v. Queens, 11102 LLC.
Yeah, specifically, we are diving into a motion for relief that was filed in February 2026 by the plaintiff's attorney, Paul Bettetti.
And this document, it just exposes the hidden machinery of litigation support.
It really looks at what happens when attorneys allegedly cross that line from, just preparing a witness to actively manufacturing truth.
So we're going to dissect how independent medical testimony is constructed behind closed doors. We have the actual specific written directives they use to silence objective medical findings.
And we'll get into the severe legal penalties designed to protect the integrity of the courtroom from exactly this kind of thing.
Let's set the stage first. To understand how truth gets manipulated like this, we have to look at the baseline expectation of the judicial system, right?
Yeah, let's look at the power dynamics here.
So this is a personal injury lawsuit. The plaintiff is Enid Tovar, and the defendant's legal team is the Gold Law Firm. And in personal injury cases, defense teams routinely hire doctors to perform an independent medical examination, an IME, on the plaintiff.
Right, very standard practice.
Here, Gold Law used a physician named Dr. Alexandra Kerr. But we really need to pause and recognize the vulnerability in this setup for the plaintiff.
Oh, absolutely.
A plaintiff is legally compelled to submit their physical body to an examination by a doctor hired by the very people trying to defeat their lawsuit.
The stakes of that forced interaction are just incredibly high. And the court serves this crucial gatekeeping function to balance that vulnerability. I mean, the entire justice system relies on the foundational premise that an IME is exactly what it claims to be, which is independent.
Independent, yeah.
So when that doctor takes the stand, the judge and the jury, they assume the testimony is the product of the doctor's own unvarnished, objective medical judgment. The jury looks at that pristine medical credential and they just trust that the person holding it is giving them the whole truth.
Okay, let's unpack this with an analogy. It's kind of like hiring a supposedly independent home inspector before buying a house, right?
Hey, yeah.
You're relying entirely on their pristine 50-page report without knowing that the seller secretly handed the inspector a memo saying, whatever you do, do not mention the termites in the basement.
That's a great way to put it. But the danger in your analogy isn't just that the termites exist. The real danger is that the report gives you this false sense of security.
Oh, because you think you're safe.
Exactly. You think you have the whole picture, but your reality has been artificially constrained. In the legal system, if the court cannot perform its essential function, which is assessing whether testimony is reliable and complete, then the truth-seeking role of the court just collapses entirely.
So we've established the expectation of independence and the immense power an IME holds over a jury. Now, let's look at the physical evidence that shattered that expectation in this specific case.
The smoking gun.
The smoking gun. The motion centers around a document referred to as the SCS letter.
Right. So SCS stands for Support Claim Services. They are the litigation support entity that was employed by the Gold Law Firm to facilitate this medical exam.
And we really need to look into who SCS is, because it provides some pretty critical context here.
Yeah, they are not some small, unknown mom-and-pop vendor. In fact, they were the subject of a massive civil RKO lawsuit.
Wait, RKO lawsuit?
Yeah. Sky Medical Supply, Inc., v. SCS Support Claim Services, Inc.
Wow.
It was filed way back in December 2012 in federal court. Judge Pamela K. Chen was presiding, and Stephen I. Flock was the referral.
2012. It involved incredibly complex allegations of systemic fraud. And this case miraculously dragged on for over 13 years before finally being terminated in February 2026.
January 2026. So this 14-year federal ICO lawsuit was overlapping with the timeline of Enid Tovar's personal injury case.
Exactly.
That underscores a massive point about legal responsibility. Defense counsel cannot just blindly outsource their witness handling, right? They have an absolute duty to vet their litigation support partners. They do. The law firm is ultimately responsible for the evidence they present to the court. Entities like SCS and the attorneys who hire them must understand what actions are permissible under the law and, more importantly, what actions are strictly forbidden.
You can't just outsource unethical behavior to a third-party vendor and claim you have clean hands.
Exactly. Medical opinions cannot be swayed or altered.
Okay, so let's get into what SCS actually did here. The motion details how, before Dr. Kerr ever examined the plaintiff, SCS sent her a cover letter.
And to be clear, this wasn't just a standard introductory letter with directions to the clinic.
No, it contained explicit, mandatory directives dictating what she could and could not say in her medical report.
Which is wild.
Reading these directives is genuinely shocking, because they basically dictate medical silence. Let's look at Rule 6 from the letter.
Okay.
It says, regarding objective clinical diagnoses, quote, if causally related to the date of the accident, then do not give comment. And they literally capitalize do not.
An objective clinical diagnosis is something measurable. It's an MRI showing a torn ligament, or a reflex test that shows nerve damage, or an X-ray of a fracture.
Right, hard evidence.
Yeah, and the letter is instructing the doctor, if you find measurable proof that this person was injured by this specific accident, keep it to yourself.
Unbelievable. Then there's Rule 10. It asks the doctor to address if there is objective evidence of limitations from a medical standpoint.
And what does it say?
The letter instructs, specific limitations is not being asked to be discussed. It tells the doctor that if the claimant displays objective limitations, just state mild or moderate.
Think about the psychological impact of those specific words on a jury.
Yeah, mild or moderate.
Right, a plaintiff might have severe, totally life-altering limitations. The doctor performs the physical exam, sees those limitations firsthand, but the jury only ever hears the words mild or moderate because the doctor was given a predetermined script.
And Rule 12 just takes this to its absolute limit.
Okay.
It says, if there is no objective evidence of permanency, please state so. But if there is objective evidence, quote, then please refrain from comment.
It's a complete heads I win, tails you lose instruction. If the medical evidence helps the defense, shout it from the rooftops. But if the medical evidence helps the plaintiff, pretend it simply doesn't exist.
Okay, I have to play devil's advocate here for a second.
Sure.
Because lawyers prep witnesses all the time, right?
I do.
Isn't it completely normal and permissible for defense counsel to work with expert medical witnesses and provide, some level of instruction?
Up to a point, yes.
Like, for instance, telling an expert they don't need to comment on causal relation because causality has already been established for the scope of the litigation. Isn't that just keeping them on track?
So what's fascinating here is the distinction between permissible preparation and impermissible manipulation. That is the crux of this entire issue. Guiding an expert to stay within the legal scope of their specific assignment. Totally permissible. Advising on report formatting, scheduling, or, like you said, telling a doctor, hey, liability is already decided. We only need you to evaluate the extent of the damages. That is standard ethical practice.
So the line is drawn at altering the medical findings themselves.
Exactly. It is one thing to tell an expert, we only need you to evaluate the knee, not the shoulder.
Right.
It is an entirely different thing to say, evaluate the knee, but if you find objective damage, hide it.
Wow, yeah, that's a huge difference.
Medical opinions cannot be swayed or altered by the attorneys paying the bill. These written directives from SCS, they didn't preserve the expert's neutrality by keeping them on topic. They manufactured a false neutrality by mandating silence on objective medical facts that hurt the defense's case.
Okay, so a letter full of hidden rules is damning on paper. But the ultimate question for the trial was whether the doctor actually followed those rules when it mattered most.
Right, because the paper means nothing unless it influences the testimony.
Exactly. This brings us to where the paper trail collides with courtroom reality. January 21st, 2026.
Take us there.
Bring yourself into that courtroom. Dr. Kerr is on the stand, testifying under oath as an independent medical expert. Paul Bettetti, the plaintiff's attorney, has somehow obtained this letter, and he confronts her directly with it in front of the jury.
You can just imagine the tension in that room. This is the moment the illusion of independence is tested in real time.
I want to read the exact exchange from the trial transcript because it leaves absolutely zero room for interpretation.
Let's hear it.
The plaintiff's attorney asks, just so I make sure the jury hears you clearly, you are instructed in this case to leave out objective evidence that Ms. Tovar is suffering from physical limitations.
And her answer.
Dr. Kerr's answer is yes.
Wow. A single one-word answer that completely unravels the defense's presentation.
Yes. Just yes.
She admitted under oath that the hidden directives were operative and that she actually followed them. She consciously omitted evidence based on a third party's instructions.
Here's where it gets really interesting, though. After that devastating admission on cross-examination, Gold Law tried to fix the damage.
Oh, I'm sure they did.
On redirect examination, they tried to, rehabilitate their expert. They asked her generalized questions, trying to get her to deny that she would ever follow improper instructions or be inappropriately influenced by anyone.
Which is a standard procedural move for a lawyer in panic mode. But logically, it falls completely flat.
Why is that?
Because generalized denials don't erase a specific, direct admission to a specific question. She had just looked at the SCS letter and confirmed, yes, in this case, I was instructed to omit evidence.
Right.
You can't put that genie back in the bottle by having the witness later claim, well, I'm generally a very independent person. The testimony presented to the court was governed by undisclosed directives. The independence was just a mirage.
But listen, Enid Tovar ultimately prevailed. She won her case.
She did.
So a skeptic might look at this and say, hey, didn't the system work? The lawyer found the letter, confronted the doctor, the jury heard the truth, and the plaintiff won. No harm, no foul. Right.
A defense team would absolutely try to make that argument. They'd claim any error was harmless. But the legal motion tears that apart by explaining this concept of concrete prejudice.
Concrete prejudice. Okay, let's explore the psychology behind that. In behavioral economics, there's a concept called anchoring bias.
Yes, exactly.
When a jury hears an authoritative figure, like a doctor, state that an injury is merely mild or moderate, that drops an anchor in the jury's mind.
Right. It sets the baseline.
Even if the plaintiff's lawyer later exposes the doctor's hidden instructions, you can't just unring that bell. The jury's baseline perception of the injury has already been artificially lowered.
And that psychological damage is exactly why the harm is concrete. The plaintiff, Enid Tovar, was forced to expend massive amounts of time, energy, and financial resources just to expose this deception.
Because the burden was put entirely on her.
Exactly. She had to proceed to verdict, fighting an uphill battle against a narrative that was fraudulently presented to the jury right from the start.
And cross-examination only happens after the doctor has already testified and painted that misleading picture during direct examination.
Once the jury hears that initial minimized assessment, exposing the lie later doesn't magically reset their perception back to zero. The plaintiff was forced to overcome an artificial deficit that was created by intentional manipulation.
So now that this deception has been laid bare, what happens to the law firm that orchestrated it? Because you can't just say oops and walk away from manufacturing testimony.
Yeah, you definitely cannot. And this leads us to the legal weapon the plaintiff is using to strike back, which is New York Judiciary Law, Section 487.
The motion describes Section 487 as a uniquely punitive law. It's not just a slap on the wrist or like a minor procedural sanction.
Not at all. Section 487 is designed specifically to target attorneys who practice intentional deceit upon the court. It is basically the legal system's immune response to corruption from within its own ranks.
Okay, let's break down the key nuances of this law, because it operates a bit differently than what you might expect from standard malpractice or ethics rules.
Sure.
First of all, it does not require a chronic pattern of bad behavior. You don't get 3 strikes. A single act of intentional deceit is enough to trigger it.
And critically, it doesn't even require the deceit to be successful.
Really? Even if the jury didn't buy it?
Exactly. The law focuses entirely on the intent to deceive, not on whether the jury actually fell for the lie. As the courts have noted, limiting this law to only successful deceits would run counter to the whole point of the statute.
Which is what?
To enforce an attorney's special obligation to protect the courts.
That raises a really interesting point about the nature of a lie in a legal setting. Gold Law might argue, well, we never explicitly lied to the judge. We never stood up and said Dr. Kerr was perfectly unbiased. We just didn't mention the letter.
Right.
But Section 487 covered that too, doesn't it?
It does, and this brings us to the crucial legal distinction between omission and commission. The motion cites precedent establishing that deceit isn't just speaking a falsehood out loud.
Right.
When an attorney has a duty to speak, silence can constitute fraudulent concealment.
Because when you call an expert witness to the stand, the act of presenting them to the court as an independent medical examiner, that is an implicit guarantee of their independence.
Yes.
So quietly hiding the SCS letter that explicitly removed that independence, that makes the silence the core deceit.
You cannot hand the court a rigged deck of cards and then claim innocence just because you didn't explicitly announce that the deck was rigged. The act of presenting the witness as independent is the affirmative misrepresentation.
And the consequence for this under Section 487 is brutal. It mandates treble damages.
Triple the damage.
Triple. Let's think about the economics of deterrence here for a second. If the penalty for getting caught manipulating a witness is just paying a small fine or, covering the other side's hourly attorney fees for the afternoon.
A massive law firm will just price that risk right into their business model.
Exactly. It just becomes a standard operating expense.
And you see exactly why the legislature created such a harsh punitive penalty. It isn't just about compensating the plaintiff for the extra work.
Right.
It is about protecting the institutional integrity of the judicial system itself. Treble damages ensures that the financial risk of deceit vastly outweighs any potential strategic reward. It threatens the firm's bottom line in a way that forces compliance.
Because if the court can't trust the evidence, the judge doesn't have the time or resources to independently investigate every single witness to make sure they aren't being secretly manipulated by a third-party vendor.
Right. Courts rely entirely on the candor of the attorneys appearing before them. If courts cannot trust that the evidence presented is free from undisclosed manipulation, the entire truth-seeking function of the justice system collapses.
It really does.
It turns a court of law into a theater production, where the outcome is decided by who has the better scriptwriters rather than who actually has the facts.
So what does this all mean for you? We started this deep dive looking at a routine personal injury trial in Queens, but we uncovered a systemic attempt to manipulate medical truth using a litigation support proxy.
Which really highlights the vital importance of transparency in expert testimony.
It does. It shows that true independence isn't just a label you can slap onto a witness.
No, it requires an environment completely free from coercive, hidden instructions.
And it serves as a massive warning label for how we consume information. Whenever you are presented with independent expert analysis, whether you're sitting on a jury in a legal setting, or you're receiving a medical diagnosis from a doctor hired by an insurance company, or even when you're just watching an expert on the evening news,
You have to critically evaluate the setup.
you really do. You have to ask yourself, what unseen constraints or written directives might be shaping their silence?
Because as we've seen today, sometimes the most important part of an expert's opinion is the part they were explicitly forbidden from saying out loud.
Which leaves us with a truly chilling final thought to ponder. In this specific case, Enid Tovar had a skilled attorney who managed to uncover the SCS letter.
He got it into evidence.
Yeah, he forced the doctor to admit to it on the witness stand under oath. It was basically a perfect storm of uncovering the truth.
It really makes you wonder about the numbers, doesn't it?
It really does. How many thousands of supposedly independent medical evaluations are submitted to courts, to insurance companies, and to regulators every single day across the country where the hidden instruction letter is simply never found?
Wow.
How much of our established reality, the facts that decide our legal and medical fates, is actually just strategically mandated silence? You think you're getting the unvarnished truth right up until you find out about the secret list.